We're going to start from the beginning of this just to refresh everybody's memory, because I actually want to go through the lawsuit of Alex Jones. You will remember that Alex Jones is in bankruptcy court right now in Texas, where they are trying to execute on a $1.4 billion judgment against Alex Jones, Free Speech Systems, the parent companies that was operating InfoWars. And we live in such a batshit crazy world that people probably forgot about all of the backdrop to the Alex Jones story, to the Alex Jones persecution. The fact that it was something of an intelligence-driven operation against Alex Jones that only started pretty much after he helped Trump beat Hillary Clinton, where you had actual FBI looking for potential litigants to litigate against Alex Jones, intentional infliction of emotional distress. There were some unfair business practices claims out of Connecticut where they were saying that he was profiting commercially off of his lies, as if that would be even a legitimate cause of action, even if the theory worked out. It wasn't false advertisement of products. It was advertising products while spreading, according to them, disinformation. Imagine if that were the criteria, the field day you could have with CNN, MSNBC, CNBC, any MSM outlet that spread propaganda, disinformation, misinformation, whether it was about Kyle Rittenhouse, Nicholas Sandmann, while also running ads on their program and monetizing their content. Imagine if that were the case. So they took these cases in Connecticut, defaulted Alex Jones into liability in Connecticut, which they then used to default Alex Jones InfoWars into liability in Texas. Now, we're just going to show the receipts just to refresh everybody's memory before we get into Alex Jones's claim in the context of the bankruptcy. Now that the Supreme Court has refused to listen to this, to hear the case, this is from back in the day, NPR. Conspiracy theorist Alex Jones ruled liable in Sandy Hook defamation case. And they always have to use a very unflattering picture of the man that they're trying to demonize, vilify, bankrupt, jail, kill, whatever. Family members of some of the victims in the 2012 Sandy Hook elementary school shootings have won a court battle by default. Remember this, because when we get into Alex Jones's claim and how it's constitutional violations, because the judge took away the trial by jury, the judge basically usurped or abdicated the constitutional roles of a judge and jury and basically gave it to the plaintiffs to adjudicate their own success, their own victory. He won the court by default against right-wing media personality Alex Jones. Yeah. A Monday ruling from a Connecticut court, which found Jones and the other defendants liable for defamation, brought swift reaction from an attorney representing the families, high-profile politicians, yada, yada, yada. Connecticut judge, remember her name, Barbara Bellis, cited the defendants' quote, willful non-compliance with the discovery process as the reasoning behind the ruling. Bellis noted that defendants failed to turn over financial and analytic data that were requested multiple times by the Sandy Hook family plaintiffs. Remember, by this time, Alex had been shut out of his Google accounts, Facebook accounts. They're asking for analytics that he no longer has. But appreciate also what they're asking for. They're asking for the finances as relates to the alleged defamatory intentional infliction of emotional distress statements. They never made the evidence of the statements. They never made the evidence of the damages. They say, oh, you didn't show us the analytics behind the financials. And so we default you into liability where the plaintiffs don't even have to prove their case. Attorney Chris Matei, who represents the victim's family in the suit, said statements, they were grateful for Monday's ruling. Of course, saves them their day in court. But said their battle to shed light on how deeply Mr. Jones has harmed their families continues. Jones was given every opportunity to comply, but when he chose instead to withhold evidence for more than 2 years, the court was left with no choice. No, of course. Remember, we'll back it out here. That was one element. They never proved their case. They never argued for their case. They never argued against statutory issues, legal issues, or even made any evidence of their claim. Judge Bellis said, liability into default. We'll have a hearing on the quantum. Okay, so that was part one, to refresh your memories. Part two, Supreme Court doesn't hear Alex Jones's petition to have these lower courts decisions overturned. This was from October 2025. Supreme Court declines to hear Alex Jones' appeal. Last week, conservative media personality Alex Jones filed an emergency appeal with the Supreme Court asking the justices to pause a lower court ruling that would require him to pay more than $1.4 billion for making false claims about the 2012 school shooting at Sandy Hook. I mean, imagine if this was the new ruling and people saying that the Butler, Pennsylvania shooting on Trump was a hoax. It's $1 billion right there. Oh, that Trump it was a ketchup pack, and he set it up himself. Last week, the conservative media, okay, fine. As the applicant noted, it was the second request for the Supreme Court's help in a little over a month. On September 5th, Jones urged the court to hear his appeal of lower court proceedings, contending that he improperly was found liable for defamation and emotional distress experienced by the families. The justices considered the petition for reviewing, yada, 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 and announced Tuesday that they will not hear Jones's appeal. Well, we know who Alex Jones is. We know what happened. Did Alex Jones pay the families? After the default judgments were announced, Jones and Free Speech Systems filed for bankruptcy protection. Sandy Hook families became part of those proceedings, first to try to prevent the bankruptcy proceedings from stalling their pre-existing cases, and then to take part in negotiations on how they would pay them. In June, Chris Lopez, the judge, ordered the liquidation of Jones' personal assets, including his stake in InfoWars. That decision led to high-profile auction of InfoWars and a dispute between the bidders. Let me just see here. Is this where we got... another thing, by the way, just to remember, in terms of this persecution. When you had one of the attorneys say, this is not about justice, I'm paraphrasing, this is about shutting Alex Jones up. They wanted to buy his likeness out of bankruptcy. You have to appreciate what that means. They wanted, as one of the assets of the bankruptcy, Alex Jones's likeness and image, so that they could effectively own not only InfoWars, not only Alex Jones, but so they can own his voice, his likeness, his image in perpetuity. Now listen to this. This is from Above the Law, 2024, just refresh everybody's memory. Alex Jones' lawyers object to entering his client's words into the record. The never-ending Alex Jones bankruptcy stories continues this afternoon in a Texas courtroom. As part of this writing, the shitposter's lawyers are challenging Chapter 7 trustee Murray's selection of global... Oh, yeah, that's right. This is when the Bee was trying to buy his stuff. As with most of Jones' production, it's a shit show. This is a guy... This is someone you can rely on. The complaint alleged gross malfeasance by the trustee, attacked the underlying state court judgments, and insisted that the sale of the IP assets was definitionally illegal. Remember how they defined it. Mr. Jones has property rights in the Jones IP rights, which he brings this action to both obtain a declaration of ownership of and to protect through injunctive relief against anyone's unauthorized use thereof, including without limitation, Alex Jones's unique personal name, image, likeness, unique voice, and or other personal identifying attributes associated with Alex Jones, which belong to him personally and cannot be sold. Among other things, consumers will suffer massive market confusion if his personal rights are marketed by anyone other than himself. Remember, we talked about it at the time. And then we saw that it actually came to fruition. They wanted to actually claim as an asset in the bankruptcy that they could seize in satisfaction of this bullcrap judgment, Alex Jones's voice and likeness. And what I said at the time is, holy crap, they want to basically use his voice to create AI-generated messaging in his voice that would totally either undermine everything he said in the past or be used to satirize him into a legacy of mere satire. And that's exactly what happened when The Onion came in there and tried to buy up the assets and turn InfoWars into something as unfunny as The Onion. And so that is the broad context of what was going on in this persecution. It was lawfare of the highest order. It was activist judges in these liberal districts, because you think Texas, okay, fine. Austin is closer to Connecticut than it is to traditional Texas. And it was lawfare from the beginning. They didn't foreclose or eliminate any positive defenses by Alex Jones. They just defaulted him into liability based on concocted, manufactured, and outright lies of alleged noncompliance with discovery. Alex Jones petitions the Supreme Court twice, and they say no. I don't know what other remedy Alex Jones, InfoWars, etc., could have to the Supreme Court where they can right this wrong, because it is a wrong, whether you like Alex Jones or not, whether or not you think some of the things he said were stupid, wrong, hurtful, $1.4 billion hurtful for what Alex Jones did in fact say, if you even knew it, a few statements, a few minutes over a decade. He wasn't allowed to say he said sorry. He wasn't allowed to say he acknowledged that the shooting happened. He wasn't allowed to say he acknowledged that the kids were murdered that day. He wasn't allowed to say that he retracted and apologized. He wasn't allowed to affirm or assert his innocence under penalty of contempt. That was the Texas judge. Defaulted into $1.4 billion. They want to take everything, and not just everything that he has, the future of his own likeness. Now, faced with that, what has he done recently? We talked about it briefly yesterday during the Viva and Barnes Law for the People. He's filed a motion in the context of the bankruptcy proceedings. You can see here, I'm going to just go through the highlight paragraphs of this so that we can understand what's going on, and then I'll get to my black pill conclusion, which is that it's not going to do a darn thing. This is the lawsuit. This is the claim in the United States Bankruptcy Court for the Southern District of Texas, Houston Division, Alexander E., which I believe stands for Emmerich Jones, the debtor. You get the plaintiffs. Jones' Second Amendment answer, affirmative defenses subject thereto and counterclaims. To the Honorable Lopez. Judge Lopez has been the most reasonable judge in all of this. It's in bankruptcy court, and if the bankruptcy law and bankruptcy court system in the U.S. is anything like it was in Canada, you tend to have commercially reasonable judges in there. In connection with the Connecticut counterclaim, let's go over here. Jones incorporates by reference the admissions and all of this. We summarize what was in the other one, and now we get into ours. Second amended counterclaim. To the Honorable Judge of said court, defendant and counterclaim plaintiff Alex Emmerich Jones, herein Alex Jones, for himself on behalf of all of his companies, yada yada, files this second amended counterclaim pursuant to 42 U.S.C. and the United States Constitution as to the various Connecticut counterclaim defendants, yada yada yada. All right, we won't get too far into the weeds of the introduction. As outset, for the sake of clarity, Jones makes it clear that counterclaim does not challenge the filing of the stuff. This action instead addresses a separate and independent constitutional injury. The State District Court of Connecticut's abdication of its non-delegable judicial responsibilities in a civil case involving a media defendant, speech matters of public concern, and claims brought by public figures involving fundamental constitutional rights. You know what my problem with this is? Not to be blackpilled, or not because I don't like Alex Jones. I do. He's bringing a constitutional claim in the context of the bankruptcy proceedings where the Supreme Court of these United States of America has already refused to hear, to overturn, to contemplate what went on at not just the lower court level, but the appellate level. So this is like I said on InfoWars with Brianna Morella this morning, this might not be a case to win in the courts, but it might be a case or a motion to wage in the court of public opinion. There's constitutional violations, free speech, excessive fines and seizures, and basic due process. Due process. How do Americans say it? Process or process? Abdication of its non-delegable judicial responsibilities. There's a principle in law that says, delegatum non potest delegar. Those to whom things have been delegated cannot themselves choose to delegate to somebody else. And to some extent, the law gave a certain power to the courts, and the courts can't then say, we're not going to adjudicate on the evidence. We're not going to allow a jury to hear it. We're just going to let the plaintiffs default their way into liability. So that is intro element of this. Let me just get to the next paragraph here. I lost my page. Paragraph 6, Jones is without question a press media defendant. His daily broadcast reached tens of millions. They basically stripped Alex Jones of his free speech, due process, and then imposed excessive fines. Paragraph 14. We're going to scroll a little bit. This is old school. Old school vlogs in real time, live, daily, 3 o'clock on Rumble. As to the Connecticut judgment, this counterclaim additionally asserts that given its size, it constitutes an unconstitutional taking of Jones's property in violation of the Fifth Amendment of the Constitution and unconstitutional excessive fine and penalty under the Eighth, both incorporated under the 14th Amendment, which could not have happened but for the intentional violations of civil rights. I'm going to bring this out here for a second. Like people think, oh, okay, they had a trial. They didn't. Well, he was defaulted into liability. That's one violation. He wasn't allowed to avail himself to free speech rights, discourse on matters of public interest, the criteria that applies to public figures, whether you like it or not. Everyone who was obviously unwillingly thrown into the spotlight under Sandy Hook are what we refer to as single-purpose public figures. It was the news for a very long period of time, and therefore you have to show that when someone made statements that might have been false, that it was made with actual malice, which is what the criteria is when it comes to public figures. But you can be what they refer to as a single-purpose public figure on one specific issue. So they violated rights, imposed an excessive fine, but upon some people say, well, it was a jury that did it. That doesn't mean anything. You don't get to throw out due process just because a jury now has been unduly empowered to impose an excessive fine, which constitutes takings. Now, get ready for Viva Immature, paragraph 104. You can scroll on. This is largely repetitive of what we've already covered. They didn't let him bring in Hillary Clinton to talk about how this lawfare got started. That's evidence, which they never needed because they never got to any hearing on the merits. Jones's constitutional rights were violated. Paragraph 104, in relinquishing its judicial duties and responsibilities and its adjudicative function, conferring such on the counterclaim defendants, Jones was deprived of his inalienable constitutional rights in violation of Section 42 U.S.C. 1983, including his right to freedom of the press and freedom of speech. As a result of this abdication, you have to just bear in mind what happened. This is like the case of every Spider-Man pointing at the other person. Judge Bellis says I don't need to adjudicate any evidence. Jury doesn't need to hear any evidence. I say that Alex Jones defaulted on his discovery obligations to such a degree that not only is he foreclosed from pleading, that would mean he doesn't get to defend himself, but plaintiffs still need to prove their case. Plaintiffs don't need to prove their case anymore. It could be time barred. Doesn't matter. The statements could be materially true. Doesn't matter. Alex Jones might not have been the one to initiate the statements, which was the case. Doesn't matter. They bypassed any evidentiary hearing altogether because of an activist judge who used as a pretextual excuse alleged discovery violations. Now, by the way, you know this. I've been a lawyer for a long time. Try to look up a case where failure to comply with discovery has resulted in a liability by default finding. Try it. It'll take you a while. You might even be hard-pressed to find cases where there was actual destruction of evidence and a person was defaulted into liability. So I got a cough again. So Alex has filed this. I don't see it going anywhere because what you have is basically a second kick at the can, but at a lower level of the court system where the upper level, the Supreme Court has already refused to hear it. But maybe if this gets enough, I say traction for lack of a better word, if this gets enough attention, then people will say, maybe the Supreme Court should finally rule on this. Maybe the Supreme Court should rule whether or not it's unconstitutional to default a defendant into liability. Maybe a judge of the Supreme Court should determine whether or not it's unconstitutional to basically say a judge can decide that the due process is very selective. But I don't think this is going to go anywhere because the Supreme Court has already said no. He's going to now ask a bankruptcy court to acknowledge constitutional violations, First Amendment, Fifth Amendment, Eighth Amendment, I think 14th Amendment, that the Supreme Court itself has, for some reason, refused to hear. Maybe there's another path to get back to the Supreme Court because maybe if Judge Lopez of the Bankruptcy Division doesn't listen to this, doesn't hear this case, Alex can then petition the Supreme Court and say, you need to hear this. Now you absolutely need to hear it. What am I supposed to do? You know what's going to drive me crazy? I've been on the wrong microphone the entire show, and I'm not going to change it right now. Nobody corrected me on the microphone? The other question I have in all of this is where the hell is Harmeet Dillon? Where the hell is the Civil Rights Division of the Department of Justice? This is an obvious, abject violation of civil rights. Obvious. And on multiple fronts. Nothing. And you know why there's nothing? Politics. Am I wearing the shirt? No, I'm not. I'm wearing the Viva Fry shirt. Politics ruins everything. At some point, to some people, and Robert Barnes, last night during our Viva and Barnes Law for the People Sunday night show, he's got his theory that allegedly, by rumors, and it's Rumor Inc., take it for what it's worth, but it doesn't even matter because we're at Consequences Inc., and the Consequences Inc. are thus far, Harmeet Dillon, Civil Rights Division, DOJ has not intervened in this egregious violation. The rumor is that Todd Blanche, who's been a Democrat the better part of his life, arguably, or maybe not, an anti-Trump Democrat up until recently, quashed it and said, no, we're not getting involved in this. And Harmeet, you're not getting involved with this. You'll do the low-hanging fruit, and Pam Bondi's going to screw that one up with the church in Minnesota. But Alex Jones, it's too politically unpopular. The Democrats think that he got what he deserved. The Democrats like this precedent where you can now, sue people for billions of dollars for intentional infliction of emotional distress. I mean, they like the precedent because they used it against Donald Trump for allegedly defaming E. Jean Carroll. Sums that are beyond comprehension. Let me just do it. So Harmeet is AWOL, and not just on this one. And you wait, you don't want to be an ingrate. You don't want to push people away if they're taking their time for some strategic reason. But nothing is happening. And this precedent, which violated every norm of procedural fairness, every norm of legal standards, stands to this day. You got a Supreme Court that, like it was too cowardly in 2020 to deal with the election cases, too cowardly in 2025, to take up the Alex Jones. And now you got the victim of lawfare, the victim of constitutional violations, the victim of due process, trying to get a second kick at the can before the Bankruptcy Division to undo the damage that the courts of Connecticut, the courts of Texas have done, and that the Supreme Court has refused to undo. And now you don't have the Civil Rights Division getting involved, not with this. And again, not to be too negative, but I'm not going to tag Harmeet because I'm not trying to be annoying anymore. Plus, I'm, whatever. Who am I? There's always a good reason to do nothing. Tina Peters rotting away in a Colorado jail for blowing the whistle on election fraud. Dexter Taylor rotting away in a New York jail for peacefully exercising his Second Amendment rights. No deep state arrests. No Russiagate hoax arrests. No election fraud arrests. Georgia investigation pending because they did something there. James Comey, Leticia James probably holding hands, rearranging shells on a beach. Just shut up and wait, and don't be a black-pilling panicking. That's where we're at. And it's a big problem. Because, there's a philosophical story. What is it called? It's somebody's ass, and not in the sense of a butt. Herodotus's ass, the ass philosophy dies deciding between bales of hay. Let me just get the actual name for it. It's called Buridan's Ass, is a 14th century philosophical thought experiment often attributed to Jean Buridan. Buridan's Ass. Don't forget this one. This is a great one. It's not entirely applicable, but conceptually it is, shut up and wait, shut up and wait. You'll get it later, shut up and wait. Oh, and it's too late. Buridan's Ass is a 14th century philosophical thought experiment often attributed to Jean Buridan, though likely developed as a critique of his work that explores free will, determinism, and rational decision-making. It depicts a hypothetical ass perfectly equidistant between two identical, equally desirable bales of hay, resulting in the animal starving to death, doesn't say that, but starving, due to an inability to rationally choose one over the other. Not exactly where we're at right now, but you see where I'm going, mutatis mutandis. It's like, just wait. Wait until when? Wait until Tina Peters is dead and then, posthumously vindicate her? We give her some medal in death? Wait for what? For Dexter Taylor? Who's, I forget how old now, 56, 60 years old? Just wait for him to wither away, and then they'll get to it. Oh yeah, we'll affirm the Second Amendment rights to peacefully, lawfully assemble a firearm in your own apartment. Just wait with Alex Jones. Let's let it play out, and so that in 5 years from now, when the new standard has been baked into societal norms, you'll have your vindication like we had in Canada on our COVID cases. Just wait. 4 years from now, well, they overturned some of the edicts and the declaration of the emergency. Well, nobody cares anymore. So my understanding is that it was politically motivated, for which they did not intervene in Alex Jones's case. Now he's left fighting on his own. And maybe if there's enough of a political stir, legal stir, the Supreme Court might take this case up and undo what has been an absolute egregious injustice and setting of an absolute untenable, horrible standard going forward. And if Harmeet is listening, better late than never, but at some point it does become too late, especially when the balance of power might shift and then you're going to have other battles. Well, now we can't do it in 2026 because we got to focus on winning 2028. So Alex, sorry, you'll just have to be bankrupt and keep paying this $1.6 billion, much of which is never dischargeable. So you'll be paying that off until you die. We've basically created an indentured servant. We outlawed slavery. We no longer allow for indentured servants. But Alex, you're going to be paying other people for the rest of your life. And that's all I have to say about that.